Today we're going to be talking about Chapter 2 in our textbook. The themes are the courts and legal reasoning. Um, Today's video I'm going to try to keep it short, but I want to highlight a couple of the main themes and some of the important concepts that sort of undergird this chapter so we can understand how it's all framed in this chapter. Okay. So the first question, kind of the overarching question of this chapter, has to do with whether or not legal reasoning is deductive. And so in order to understand kind of what the question is and so what some of the examples are, we want to think about uh, what it means for something to be deductive in the first place, for reasoning to be deductive. If you've taken a logic or an intro to philosophy class, you might know what those themes mean. But the basic idea here is that when you have deductive reasoning, you've got some set of premises or reasons or principles, and once you're clear about what your premises are or what your reasons are, the conclusion just follows from those premises. Like it's sort of not even debatable what the conclusion would be. It just follows straightforwardly from the principles. So a common example we use in a philosophy class or a logic class would be something like this. Suppose I give you a fact. I say Socrates is a man. And suppose I give you a rule. All men are mortal. So I give you those two pieces of information. Socrates is a man and all men are mortal. And then I could ask you, what conclusion could you draw from those two premises? And then hopefully you would see, as most students do, that we would draw the conclusion that Socrates is mortal. If Socrates is a man and all men are mortal, then Socrates must be mortal, right? So it follows from it. And it's sort of not even debatable, right? So like you can't even argue that follows straightforwardly from those premises. That's a sort of prototypical deductive argument. And so if you're clear about what the principles are, what the premises are, the conclusion will just follow from them. It'll fall out of them, so to speak. And so another kind of example of this that I'll use is it has to do with like geometry. If you remember back to geometry class in high school, you probably remember doing proofs. And one way of doing a proof would be like this. You start with a set of axioms, and those just are principles. You don't even argue you don't have to give any justification for the axioms, right? The axioms just are taken for granted. They're accepted as true. And then once you've got those axioms, you can start deducing other things from those axioms once you plug in specific cases. And so suppose you have an axiom like this: the interior angles of a triangle sum to 180 degrees. You've probably heard that before, right? So now suppose, what's interesting about that is that's a sort of a general rule that applies to all triangles, right? And so now I can give you a specific case. Suppose you have a triangle that has angle A is 60 degrees, angle B is 100 degrees. What is angle C? What's the value of the third angle? And then you'd say 20 degrees is the value because they have to sum to 180. And so I can give you all these. So if I give you the rule or the axiom about the angles summing to 180 degrees, and then I give you a specific case, here's a couple measurements of the angles within this particular triangle, you can give me a conclusion that falls out of that, which is like what's the value or what's the measurement of the third angle of the triangle, right? And so you can do that with an infinite number of triangles, right? I can just keep giving you an infinite number of specific cases of triangles, and you can keep spitting out that third angle for me, right? As long as you know the first two angles. So that's an example of deductive reasoning. And so your geometry teacher can tell you straightforwardly whether you're right or wrong, because as long as we're clear about what the rule is and we're clear about what the specific case is, we know what the conclusion should be. And so the question is, how does this apply in sort of like legal cases, right? Is this what legal reasoning is like? Is this what a judge does in a case? So suppose you've got a rule like murder is maybe something about murder being illegal, and then maybe there's another rule about if you commit a murder, you have to do 30 years in prison or something like that. So you've got some set of legal rules, and then you look at the specifics of a case, right? Some person allegedly, commits a murder, and you look at the evidence of the case, and you're trying to, you determine, oh, it looks like they did. Um, it seems like they did commit this murder. Well, then once you've got the specifics of the case, once you've got the rules, well, the verdict just falls out of that. Well, now the judge just says, well, since we know that the person committed the murder, we know what the murder is wrong. We know that it carries a 30-year punishment. This person's going to prison for 30 years, something like that. So, is that what legal reasoning is like? Is that what all legal reasoning is like? You're just finding the rules that apply, finding the specifics of a particular case, and then spitting out a verdict in that case. So that's deductive reasoning. That's the question. Is legal reasoning like that? And there's some sort of different views on this, right? And so one view that gets highlighted in the text here is legal reason, legal realism, and legal realism is going to say reject this kind of at least a straightforward deductive account of legal reasoning. And what I mean by that is that a legal realist would say that a judge actually should take some responsibility for shaping the law to be as they think the law should be, to use the law to make society better. So on a straightforward deductive account, notice that it doesn't matter what the judge thinks about the law. The judge just has to find the rules that apply, assess or sort of ascertain the specifics of a case, and then apply the rules. There's no question about whether the judge supports those rules, cares about those rules, likes those rules. Do those rules make society better? Just like in your geometry class, it doesn't matter how you feel about the value of that third angle of the triangle, right? It just falls out of the rules in the specific case, right? So a legal realist is someone who would say, actually, a judge should think about how society, how culture ought to be, and use the law to make it better. And so get the verdicts that will make society better, not necessarily the verdicts that just fall straightforwardly out of the rules or past legal precedent and that sort of thing. And of course, I think you can probably see, we're not going to dive into it here in this video, but I think you can probably see pros and cons to either side here. If the law is straightforwardly deductive, you might think that helps prevent a judge from acting on her biases, right? And so if a judge were, a dyed-in-the-wool racist, and she's got a black man on trial in front of her, or versus the same case but now it's a white man or a woman or whatever, imagine all the different racial lines or demographic lines you can draw it on. If the law is straightforwardly deductive, then it doesn't matter what she thinks about those different categories of people, right? She just has to find the rule and apply it, and so it might help prevent bias. But at the same time, there also does seem to be something right about this idea that, don't we have a legal system in the first place because we want to make society better, right? And isn't it the case sometimes that if you sort of strictly adhere to a rule and kind of blindly apply it all the time, you can kind of just you end up not getting things right. Sometimes we don't want to just always strictly apply a rule, right? Sometimes we want some flexibility, some maneuverability, right, to make the right decision, even if it doesn't quite strictly apply a rule or something like that. And so I think you can see pros and cons on both sides. There's dangers, right? So if you have a judge who's interested in making society better by getting the rulings that sort of coincide with their beliefs about what it would be like for society to be better, well then, that judge, if they have the wrong idea of what makes society better, then that judge can be dangerous, right? And so there's a lot of questions on either side about which of these is better. What's the right way to sort of look at the law? How should the legal reasoning be applied? But that's the sort of basic question about deductive reasoning. One example the textbook uses too in terms of is to contrast deductive reasoning here is contrast it with kinds of legal reasoning where it's not straightforward rule application and then conclusions follow from it. One might be assessing the the quality of an eyewitness or of an eyewitness testimony or the character of an eyewitness. That's not that doesn't seem like straightforwardly deductive reasoning, right? You've got to assess whether or not a witness is reliable. There's no like rule that you're going to apply to that. There's no straightforward way of determining whether or not someone is a reliable witness, right? And so that might be an instance of sort of what we might call inductive reasoning. Again, if you've taken a logic class, you might be familiar with that term. But that's just a way, that might be one example of a kind of legal reasoning that goes on, that's germane, that's common in legal reasoning, but doesn't seem straightforwardly deductive. So maybe at the very least, legal reasoning isn't totally deductive. There might be some aspects of it that aren't. Okay, so moving on, there's another section here in the text talks about sources of the law. This is section 3 of chapter 2, and then makes this interesting distinction between specificity and generality. And there's a couple main ideas here, but the main point in this section is that there's different sources of law and different levels of specificity versus generality. And so making laws that can be understood and followed by citizens requires specificity. But making laws that can accommodate sort of, unanticipated future cases requires generality. And so these virtues require a kind of trade-off. So let's unpack that a little bit. First, the point about sources of laws. Laws come from a variety of places, right? Constitutions, acts of legislature, which would be statutes, case law, which is generated by courts, administrative regulations. There's a lot of different places where laws can come from. Okay. And if you remember back to chapter 1, a society will have like laws of recognition that help us determine what the sources of law are. Like the Constitution might be like your fundamental, ultimate law of recognition. Okay, so there's a variety of sources. And so you can imagine sorting through all the different types of laws can be a daunting task, right? One thing that makes it even more daunting to sort through all of the different types of laws from different places is this question about how specific versus how general should a law be. And oftentimes it's difficult. So you want laws to be specific enough that we can apply them, right? If a law is too general or too vague, then we just won't know what to do with it. And so in the text, you get this nice contrast between specificity and generality, right? And so the idea here is that if a law is too specific, then in one sense that could be a good thing, right? If you have a really specific law, then if that very specific case comes up, then it'll be really easy to apply that law, right? But usually what happens when we write laws is we're trying to write a law that's going to apply to a variety of cases. Right? And so we want it to cover a range of cases. We can't possibly write down a law for every specific way that you could do something sort of like illegal or wrong, something that we want you to prevent, right? So we can't say, we're not going to write so think about a law like jaywalking. We're not going to write a law that says you can't jaywalk on a country road, and you also can't jaywalk on a city road, and you also can't jaywalk between the hours of, so we're not going to write, we're going to write a general law that says something about sort of all jaywalking, right? It's going to apply to all those cases. And then anytime you've got an instance of jaywalking, we can apply that rule, right? So you don't want your law to be too specific. You need to have some level of generality so it can apply to a wide range of cases in order for the law to really be usable. But the more general you are, and therefore the less specific you are, the more you're going to come up with sort of difficult cases. And there's going to be cases where you're going to wonder whether or not the law applies in this particular case, because we didn't make the law hyper specific. Now there's a kind of vagueness to it that opens up the door for questions about whether or not that law applies, and that leads to questions about indeterminacy. And so there's a couple different sort of philosophical ideas, concepts in the background here when it comes to indeterminacy. There's a couple different ways that things can be indeterminate. So here's two broad philosophical categories of indeterminacy: metaphysical and epistemological, or epistemic indeterminacy. Epistemological indeterminacy, that's maybe the easiest one to wrap our heads around. That's just when it's just not clear what the fact of the matter is on some issue. We just don't know. Like we have limited knowledge. Epistemology has to do with the philosophy or theories of knowledge, right? And so epistemological indeterminacy might say that there is a fact of the matter to the, whether a law applies or something like that, but we just don't know whether it applies. So it's a limitation on our knowledge, and so that's why we can't determine the right answer. Metaphysical indeterminacy is a little bit different. It means that there just is no fact of the matter. It's not that we don't know it or we can't access it or we don't have enough information. It's that there just is no fact of the matter. One case of metaphysical indeterminacy that gets used, one example of this that gets used sometimes in philosophy, might have to do with something like baldness. So imagine we know that there's clear cases of people who are bald. So suppose you've got a man that has no hair on his head. Clearly he's bald. You've got a man who has a sort of full head of hair. Clearly he's not bald. Now suppose you take the man with the full head of hair and one hair at a time starts falling out of that man's head, right? Eventually he'll be bald. Eventually he'll have no hair. So we know that eventually he'll be bald. But there's a question about, when does he become bald? How many hairs have to fall out of his head before he's actually bald, right? Where's the exact point at which he becomes bald? And one answer to that question is what would be to say something like this: well, it's not that we just don't have enough knowledge. We know how many hairs are on his head, how many have fallen out, that kind of. We could track that kind of thing if we really wanted to. But rather, what it is that there's just no difference between, if I don't know how many hairs are on somebody's head, but suppose 100,000 have fallen out, and and versus 100,001 have fallen out. It doesn't seem like there's any sort of robust metaphysical difference between those 2 points on the scale, right? Where 100,000 hairs have fallen out versus 100,001 hairs have fallen out. It would be strange to say that when only 100,000 have fallen out, he's not bald, but once 100,001 have fallen out, then he is bald. It doesn't seem like baldness works that way, right? It seems like baldness is sort of a vague category. There's just no fact of the matter about exactly when he becomes bald. So that's a kind of metaphysical vagueness, a metaphysical indeterminacy. And so those two distinct categories of indeterminacy. And now we get questions about, how do laws apply, right? How do we have? Remember, we had this question about, we want laws to be general enough to apply to a number of different cases, but then it raises questions about, in specific cases, whether or not that law applies. And so an example that gets used in the textbook, right, has to do with this. So imagine that imagine that the city council notices that people keep driving their cars into the local park, and they're parking on the grass. And so this is causing damage to the park grounds. It's disrupting pedestrian traffic, and it's making the park overall just a less pleasant place to be. And so they want to establish a policy that prohibits vehicles in the park. And so this is a perfect case of the city council trying to be vague here, right? It's not that they want to prohibit Fords or Chevys or Dodges or whatever from the park, right? They want to prohibit vehicles from the park. And it's not that they want to prohibit sedans versus pickup trucks or something like that. They want to prohibit all of those things from the park. All of those things are going to ruin the grass in the park, disrupt pedestrian traffic, et cetera, et cetera. So they generalized the law. And so instead of listing all the specific vehicles, they say vehicles. They use that phrase, vehicles, to be general, right? And that seems straightforward, sensible thing to do, right? There's nothing crazy about that. But now imagine that you're, say, a new recruit to the police department, and you're on patrol near the park. And as you drive past the park, you notice that someone's operating a moped in the park. And so you're aware of the city council's new policy. And so there's a question now. Do you confront the moped operator and call to their attention that they're in violation of the no vehicles policy? Or don't you? If this were in-class discussion, I would ask you to talk about this in your small groups. I would ask you to explain your answers here. But you can see the tension here. The tension is between making the law vague enough to apply in a number of cases. So because the law is general, the police officer doesn't have to think very hard when he sees a pickup truck, doesn't have to think very hard when he sees a Toyota Camry, right? Something like that, right? When the police officer sees a pedestrian on foot, the police officer knows that that's clearly not a paradigm case, right? That applies to this law. So that person's clearly not in violation of the no vehicles policy. And so what you've got paradigm cases, easy cases, and this is how Hart talks about it, versus hard cases. So the pedestrian walking is an easy case. Clearly, they're not in violation of the law. The guy who parks his pickup truck there clearly is in violation of the no vehicles law. Now you've got the person operating the moped. Are they in violation of the no vehicles law? And on some readings, it seems like clearly they are, right? They have something that could very easily be described as a vehicle. It's got wheels, it's got an engine, that sort of thing, an internal combustion engine, that sort of thing, right? But at the same time, it's different from a car. It's only got two wheels. It's a single passenger vehicle. What if it has an electric engine instead of so what differences matter, what differences don't? That leaves some room for indeterminacy in whether the law applies in specific cases, right? And so you've got that kind of difficulty with this case. The police officer has to ask this question: does this law apply in this case? And suppose the police officer writes up a ticket for the person operating the moped. It might be perfectly reasonable for that person to go to court with their ticket and say, I don't think this law should apply to me. I don't think I really was in violation of the no vehicles policy. I think there's important differences between what the intent of this law was trying to get at and trying to prevent and what I was doing on my moped in the park. And you can have that reasonable legal debate, right? And so we can see that kind of indeterminacy in the laws. So here's the question I'll leave you with. I think that's enough for the main concepts of this chapter, but here's the question I want to leave you with. It's this. Suppose that there is this indeterminacy in the way laws are written, the way that they're applied, whether or not they apply in specific cases or not. What does that have to do with a deductive view of legal reasoning? So suppose you endorse a deductive view, that legal reasoning is purely deductive. Why might indeterminacy present a problem for that view? So you can think a little bit about that as you're continuing to process the concepts from this chapter this week.